Good afternoon. Welcome to the Epilepsy Foundation of Connecticut webinar series. This is Monica Anzalone. I will be moderating the webinar for this afternoon. For the purposes of sound quality, as usual, we just have everybody in listen-only mode, and we do welcome questions. You can type those at the bottom of your screen. You'll see a chat icon there, and we'll get those questions answered for you at the end of the presentation. So this is the second part of our spring webinar series and the last webinar before a summer break. Today we'll be talking about, continuing to talk about disability and employment, and really what to do if somebody is wrongfully terminated from a job position due to, or thinking that it is due to their epilepsy. It's not uncommon for individuals we know with epilepsy to experience discrimination in their place of employment. And often we find our clients, they don't know what action to take if they are treated unfairly or even terminated from a job because of seizures. The idea is that we want all of our clients to understand their rights under the Americans with Disability Act and what they should do should they experience discrimination in the workplace. So we're once again joined by the Greater Hartford Legal Aid Attorney, Amy Dion, who will be using case examples today to practically address this topic. Amy is a staff attorney, as I mentioned, at the Greater Hartford Legal Aid. She divides her practice between education and employment issues. In her employment practice, Amy represents clients in unemployment hearings, discrimination cases, and wage theft cases. Amy has a BA from Boston College and a JD from the University of Connecticut School of Law. She has been a member of the bar since 2007, and I welcome her to start our presentation for today.
Thank you so much. Welcome, everyone. So today we're going to talk about wrongful termination and what that means for individuals with disabilities. And talk a little bit about the legal landscape. So wrongful termination essentially means that you've been terminated in violation of a law. It could be a federal or a state law. Many times individual clients will come to us and feel that they have been wrongfully terminated. And so we sort of run through the checklist of these laws and try to figure out what exactly an employer may have violated through their actions. So we're going to talk a lot today about the Americans with Disabilities Act. That's a federal law that protects individuals with disabilities. The Rehabilitation Act sort of works hand in hand with the ADA. And I'm going to talk just a very little bit at the end about the Family and Medical Leave Act, which is a little bit separate and distinct from discrimination issues, but relevant. It could be very relevant in wrongful termination cases. And then we have, Connecticut has some very good state laws that protect persons with disabilities. So we'll spend some time talking about the Connecticut Fair Employment Practices Act. We sometimes call it CFEPA. So if you hear me say that, that's what I'm referencing. And then Connecticut also has a Family and Medical Leave Act statute that protects persons within the state. So and I know we talked a lot about this, about the ADA last time, so some of the nitty gritty I'll try to go through quickly, but the definitions, it's important to know that the ADA applies to employers with 15 or more employees. So if you work for a very small employer, the ADA is not going to protect you in that sense, but when we talk about the Connecticut state law, you may have recourse there. You need to be a qualified individual under the ADA, which means that you are able to perform the essential functions of a job with or without reasonable accommodations. The disability under the ADA means that a person has a physical or mental impairment that substantially limits one or more major life activities, that you have a record of such impairment, or you're regarded as having such an impairment. And major life activities can really sort of be anything. Self-care activities, activities of daily living, eating, sleeping, walking, or major bodily functions, which includes neurological and brain functions. And one of the important things to note under this is that an impairment that's episodic or in remission is still considered a disability if it would substantially limit you when it's active. So if you have epilepsy or a seizure disorder and it's been well controlled on medication, it could still be considered a disability for ADA purposes, because if it was active, it would substantially limit a major life activity. The ADA specifically references epilepsy. You know, there was a law change that went into effect January 1st, 2009, because the courts had been interpreting the ADA very strictly and sort of cutting people out from coverage and protections of the ADA that Congress had intended. So they amended the law, and they did put in some helpful language to make sure courts knew that it was to be very broadly construed and to protect as many people as possible. So you'll see there an individual with epilepsy would be considered to have an impairment even if the symptoms of the disorder were completely controlled by medicine. And then the next paragraph, epilepsy substantially limits neurological function. So the writers of the ADA were cognizant that, you know, epilepsy should easily qualify as a disability under the ADA. I had mentioned the Connecticut Fair Employment Practices Act, so we work with that a lot as well, and that applies to employers of 3 or more persons. So again, remember the ADA is 15 or more. If you work for a very small employer, you may still be able to file a complaint or get redress through state law. And their definition is a little different, but again, still includes individuals with epilepsy or seizure disorder. You'll see it there. Physically disabled includes any individual who has a chronic physical handicap, infirmity, impairment, including but not limited to epilepsy, and it goes on from there. So it is included in the Connecticut state law definition. And then what they define as discrimination, an employer either refuses to hire or discharges from employment any individual or discriminates against such individual in compensation or terms or conditions of employment because of, lists all those protected classes, but you'll see at the end there, physical disability. So anytime an employer is not hiring you or firing you because you have epilepsy or a seizure disorder, that's prohibited by both federal and state law. So in Connecticut, we have the Commission on Human Rights and Opportunities, which we usually refer to as CHRO. And if you are a person with a disability who's been wrongfully terminated in violation of either the ADA or the Connecticut Fair Employment Practices Act, you have the right to go to CHRO and file a discrimination complaint. And you'll see here it says any person that's aggrieved by an alleged discriminatory practice can go to CHRO and file a complaint. Normally, you know, you can either talk to an attorney or we have a lot of clients who will make, you know, CHRO will make an appointment for you to come in. They'll sit down with you. They will take the facts of your case. They'll draft the complaint and file it for you. So if you're on your own and you don't have an attorney, you can still go ahead and file, and CHRO is very helpful in doing that, and you can still file a complaint and try to you know, right that wrong. And it's important to know that when thinking, if you have been wrongfully terminated, you have only a certain amount of time to file. So you have 180 days, or about 6 months, from the date of the last act of discrimination. So if you're terminated, the clock starts running from that date. So I think this is just a very important piece to be mindful of and to be aware of. You know, you want to move pretty quickly, whether it's to make, you know, contact an attorney or set up that appointment with CHRO to further discuss your case. You have 180 days to do so. And then if you miss that 180-day deadline, remember there's a federal agency, part of the Federal Department of Labor, the Equal Employment Opportunities Commission, the EEOC. And you also could file a complaint with them. So again, any person who's been aggrieved under the ADA is able to file that complaint with the EEOC. If it's just, again, but be mindful here, if the employer has less than 15 employees and it's not a matter of federal law, but only state law, the EEOC is not going to investigate that. But if there is a federal law question under the ADA, they have a 300-day filing deadline. So if you miss the 180 days with CHRO, all hope is not lost. You're still able to file with EEOC. Again, if you have a federal claim, but just something to be very mindful of. The 300 days is certainly better and allows more time for filing, but you want to make sure that you're filing before that deadline runs. And then I just wanted to touch on, okay, so we're going to talk a little bit about cases and the framework for how sort of complaints are analyzed and assessed, and we're going to get into some facts of some cases and some details, and I'll be happy to talk more at the end if folks have questions on those. So when we're looking at anti-discrimination cases, they're analyzed under a burden shifting framework. And what that means is the plaintiff has to present a prima facie case. And that just means on its face, the allegations are enough to prove discrimination. They sort of take it at face value. So you sort of have to allege, you know, I have a disability, the employer terminated me because of that, right? So, and we'll get into the factors of a prima facie case, but that's up to the plaintiff to assert in their complaint. Then the burden shifts to the employer to give a legitimate non-discriminatory reason. So that's really their justification. Well, yes, we terminated that person, but we had a non-discriminatory reason for doing so. And then the plaintiff has a chance to sort of say, well, the reason that the employer gave is just a cover up. It's just pretext. Here's the real reason they fired me, and it's discriminatory. And that's the McDonnell-Douglas case. It's a huge federal law case, but it just sort of talks about burden shifting, how it goes back and forth. For the prima facie case, a plaintiff has a disability under the statutory definition. You need to be qualified to perform the essential functions of the job with or without reasonable accommodation. Excuse me, and the plaintiff must have suffered an adverse employment action. So wrongful termination certainly falls within that. If you've been terminated and you think it's based on your disability, then you should be able to make out a prima facie case. Essential functions of the job. I know we talked a lot about this last time, but really it's, you know, it's up to the employer what the essential functions of the job are. If there's a written job description, you know, that's kind of going to lay out what the essential functions are. You know, and you can't accommodate by removing an essential job function. You can't say, well, there's this one function I can't do. Can you accommodate me by removing that function? That's not a reasonable accommodation. To be wrong, if it's wrongful termination, you have to have informed the employer that the disability existed, because if they don't know you have epilepsy or a seizure disorder, then it would be pretty much impossible to prove that you were terminated based on their knowledge that you had a disability. So assuming that you've made them aware and tried to engage with them and they've fired you anyway and you believe it's based on that disability, then you may have a case. As we talked about, the employer gets to try to provide a legitimate non-discriminatory reason, and that is satisfied when taken as true would permit the conclusion that there was a non-discriminatory reason for the adverse action. And example of that would be if the employee engaged in misconduct. So for example, you have a disability, they know about it, they terminated you a week after you told them, but they're going to come back and say, oh, you didn't meet your timelines, you made a mistake on this huge project, you did something that, you know, violated a company policy. So that could be an example. Or they might come back and say, you know, this employee wasn't able to perform the essential functions of the job, even though we tried to reasonably accommodate them. So, and again, we'll talk about reasonable accommodations, but if you can't perform the essential functions, even with reasonable accommodations, then the employer may still terminate legally. Then, of course, you would have the chance to say that their non-discriminatory reason is not their real reason. And, this evidence of pretext could include discriminatory remarks made by supervisors, temporal proximity, which is very important. So as I mentioned before, if you have a case, if you recently, let's say 2 weeks ago, told a supervisor that you had a disability, if you had epilepsy, and you provided medical documentation from your neurologist that you were fine to work, and you could perform the essential functions of the job, and then they fire you 2 weeks later for, you can say, look how close in time that temporal proximity is, that this is evidence that it really was discriminatory. And in cases that I've worked on, I had a case recently where, the defendant said, well, there's no temporal proximity here. I think there was about a two month gap between, it was a retaliation case, a 2-month gap between when the retaliatory action had the complaint had been filed, and then 2 months later, the retaliatory action had occurred. And, the case law on this sort of says it has to happen pretty close in time. If there's no bright line rule, it's analyzed on a case-by-case basis. But it's not going to be 6 months. Like, if you tell them about your disability and 6 months later they terminate you for something, it's much harder to sort of argue that there's any temporal proximity. The case law, again, there's no bright line rule, but seem to say, it should kind of be under 2 months or, happen pretty quickly. Comparators can be good evidence of pretext. So other people who are similarly situated without disabilities who haven't experienced the same adverse conduct. So if you're a person who has seizure disorders and you've disclosed this to your employer and say you have a certain amount of work or quota that you have to do every week, and you've asked to be accommodated, but for whatever reason you're not hitting that mark and they discipline you, you kind of have to look at, okay, who are my coworkers without disabilities? Are they hitting the same numbers? And if they're not, just like you, and the employer has taken no action against them, but they've disciplined you, then that can be good evidence of pretext, right? So it really does look discriminatory if they're not behaving the same way towards non-disabled employees. Shifting justifications from the employer, this is, if they keep changing their story and can't really explain why they terminated you, that can be evidence of pretext. And employer deviation from standard protocol in dealing with the employee. Something you want to look at there is the employer policies. And, for example, if they have a progressive discipline policy and they've terminated you without sort of going through the steps of that progressive discipline, then that can be evidence of pretext as well. And something, I think one helpful thing is, if you have emails from supervisors or text message from supervisors referencing your disability in a negative or derogatory way, if there are individuals, friendly individuals who have witnessed interactions with supervisors, or the supervisor saying something negative about your disability, especially in front of other coworkers, that, that could be helpful evidence. And just make sure you're keeping those text messages and emails, print them out, as long as it's not violating any company policy to print out company email. But yeah, those are important kind of things to talk about, to think about, is what kind of evidence exists in your case. So here was one case, and we're going to talk, a lot of these cases sort of have to do with police officers. And this was a case where there was a police officer and he had epilepsy. He was demoted after having a seizure while at work. He presented a prima facie case, And then the employer said, well, we have a legitimate non-discriminatory reason because we need to protect the public safety. And, the plaintiff tried to show that that was just pretext. But the court found, I think, that in this case, that the employer's public safety concerns were legitimate, and he was not terminated because of his epilepsy. So again, when we're talking about wrongful discharge, it has to be in violation of a law. An employee, even if you have epilepsy or a seizure disorder, you can be discharged when the termination is completely unrelated to your disability. If you don't meet the legitimate requirements for the job, such as performance or production standards, with or without a reasonable accommodation. And again, that goes to the essential functions of the job. And then lastly, even if you have a disability, if it poses a direct threat to health or safety in the workplace, they may terminate you for that. So we'll talk about that. A direct threat, and this might be more rare, but it sort of depends on what industry you're in. A direct threat is a significant risk to the health or safety of others that can't be eliminated by reasonable accommodation. And some of the things they look at are the duration of the risk, the nature and severity of the harm, the likelihood that the harm will occur, and the imminence of the potential harm. One of the older cases that I looked at on this was an individual with epilepsy who worked in some sort of chlorine gas manufacturing plant, and he was sort of responsible for filling the cars with the chlorine gas and shutting off the valve when the cars got full. And so even though his epilepsy was fairly well controlled and the likelihood of him having a seizure on the job was low, they still held that the nature and severity of the potential harm, if the chlorine gas escaped and wasn't shut off, was pretty significant. So they ruled against the plaintiff in that case. So again, it really kind of depends on what industry you're in. If you work at a nuclear facility, that's more likely than if you work in retail, but just something to keep in mind. As I mentioned before, we do see many of these cases in the context of police departments. This was a case out of New York City where this applicant had applied to work for the New York City Police Department. He had a history of seizures, but he had been seizure-free for more than 2 years. His epilepsy was well controlled by medication. But nevertheless, the police department disqualified him based on his medical evaluation because they believed he'd be a threat to health and safety of others as a police officer. But the court refused to grant the defendant's motion for summary judgment in this case because there was conflicting medical evidence. The plaintiff's medical doctors, one of them was an expert in the field, said there's really, this gentleman hasn't had a seizure in years. His medication really is, well controls the seizure disorder, and we do not think he's in any way a threat. Whereas the police department's doctors said, he has to carry a gun, he has to arrest people, and they sort of barred anybody with epilepsy or a seizure disorder from being a police officer because of those sort of factors. But in this case, the court said, we can't grant summary judgment on that, and that's not, doesn't tell how it ultimately came out. They probably settled, but it just shows that in some cases, the court may say, you can't just outright bar somebody based on a direct threat theory. It has to be individualized, and you have to look at the facts of their case. But that's not how they all come out, certainly. There are other cases on police officers where they say having epilepsy or a seizure disorder, it's reasonable to say that may be a direct threat. Here's another one out of Connecticut, a fairly recent case. And the plaintiff was a social worker who worked in one of the correctional institutions here in the state. But the social work position was a hazardous duty position because they worked directly with inmates. And, even though this person, I think it says she had seizures primarily at night, hadn't really experienced one during the day, and I think fairly well controlled. She did at one point have a seizure at work and was temporarily unresponsive while she was with an inmate. And I think one of the key factors in this case was she had facility keys on her at the time of her seizure. And their policy was not to have correctional officers in the room with the social workers. So the employer terminated her because they said that having a seizure disorder was a disqualification in a hazardous duty environment. So again, this is a direct threat defense. And I think one of the interesting things in this case is that the plaintiff had not asked for any reasonable accommodations beyond, you know, she did ask to be able to use her sick time in the event that she had a seizure. And the court found that the employer's direct threat assessment was reasonable. So I kind of wonder, I'm not sure what their job description said and what their, you know, what the essential functions of that job were, but if she was not a key holder, I mean, she was a social worker, she was not a correctional officer. Had she asked maybe to have a correctional officer escort her and not hold the keys to the facility so that in the event she became incapacitated, which was pretty rare. So I think the key in that case is, you know, you want to communicate with your employer if you think there are reasonable accommodations you may need. If you're in a situation where if you're incapacitated, it could be dangerous to you or others around you, you know, what accommodations could you ask for that would make it safe for you and all those people to sort of alleviate that concern for the employer. Here's another case. This one is sort of interesting and kind of talks a little bit about reasonable accommodations. This plaintiff worked as a clinic office assistant at the University of Connecticut Health Center. She had a hearing disorder and anxiety. She was later hospitalized for seizures, and her seizures sound like they were fairly significant. She had seizures every 3 to 4 weeks, and then she'd be out of work for 5 to 7 days at a time. At some point toward the end of her employment, she was approved for Social Security disability benefits. And, you know, so they said that the court found she couldn't demonstrate she was qualified for her position because she had told the Social Security agency that she was unable to work. So that's just, that's a little wrinkle to keep in mind as well. If you're claiming in one forum that you are completely disabled and unable to work, it might make it much harder to say you are qualified to perform the essential functions of a job, depending on what that job is. So the court ruled against her on her ADA claim. For her state claim, because her attendance had, because she was out of work so often, the court found that regular attendance is fundamental to most jobs, and she had failed to prove that she could perform the essential requirements of the job, you know, essentially that regular attendance and coming to work on a regular basis. And as far as the accommodations went, you know, it started off with, I think she had presented on the hearing disorder, and so they really tried to accommodate her, and I think she answered phones, so they worked on installing low hearing devices on the phone so that she could hear better, and I think they went through a few of those. But then, you know, she said it's more about stress and anxiety, and the employer really tried to engage with her, and they made a good faith effort to accommodate her. And I don't think that they specifically refused anything she had asked for. So in that case, the court found for the employer on all those counts. So it just a sort of a very interesting case. Okay, so again, if the employer knows you have a disability and that you may need a reasonable accommodation, if they are not going to reasonably accommodate you, that could certainly be discrimination. The prima facie case for a reasonable accommodation is if you're a person with a disability within the meaning of the ADA. The employer is aware of the plaintiff's disability, and there's a reasonable accommodation that exists that the plaintiff could use to perform the essential functions of the job at issue, and the employer refused to make such accommodation. So there's case law out there about that, like the case we just discussed. I know we talked a lot about reasonable accommodations last time. can take many different forms. You know, changes to facilities, job restructuring, part-time or modified work schedules, and the employer is obligated to initiate the informal interactive process once the individual comes to them and says, I have epilepsy or a seizure disorder. I think I need this reasonable accommodation. The employer needs to engage with them and try to figure out, can they accommodate them? Sometimes placing someone in an alternative position could be a reasonable accommodation, but keep in mind that the plaintiff bears the burden of identifying a suitable position to which they can be transferred. Basically, you have to show that an existing vacant position existed that you could have been reassigned to, that you were qualified for. They're not obligated, for example, to create a job position for you just because you are no longer able to perform the essential functions of the job that you have. So if you're filing a complaint and you're going to go to a hearing or a trial, just keep this in mind that, there have to be other jobs that you could have been transferred to if a transfer is what you're looking for. And I will just say the Job Accommodation Network is a very helpful resource when thinking about reasonable accommodation. So I would just encourage you, if you think you may need a reasonable accommodation, but you're not sure what or how to structure that, that has some very good ideas for specific to individuals with epilepsy or seizure disorders. The employer doesn't have to provide a requested accommodation if it's a significant difficulty or expense for the employer, so that would be on them to prove. Here's a case about a reasonable accommodation. There was a truck driver, and he was then diagnosed with epilepsy, and as a result of that, he could no longer hold his CDL license. So he requested an accommodation in the form of a transfer to a warehouse position. And in this case, as we talked about, he was able to provide evidence that several warehouse positions were available that he was likely qualified for, but the employer terminated him instead of transferring him. And so in this case, the court said there is a material issue as to whether the employer discriminated against him. And so the court denied summary judgment at that point. Yes, and so that would then go on for further review by the court. But so again, as long as you're able to, the burden is on the plaintiff to prove that there are positions available. Retaliation is another form of discrimination that you can certainly file a complaint over. Essentially, if you've told them that you have epilepsy or a seizure disorder and you feel they're discriminating against you and you file a complaint, but you're still working there, and then you file that complaint and then a week later they fire you, that certainly looks like retaliation. So you have the right to then say they've retaliated against me for engaging in this protected activity. I filed this complaint, that's protected. And that could be retaliation. They can't coerce, intimidate, threaten, or interfere with any individual's exercise of your rights under this on account of having aided or encouraged any other individual in the exercise or enjoyment of any rights guaranteed by the ADA. Prima facie case for retaliation is that the plaintiff engaged in activity protected by the ADA. The employer knew of that activity. So again, if you can't prove that they knew about it, your retaliation claim is likely going to fail. But for example, when you file with CHRO, if you file a complaint with them, they are going to send that complaint to the employer. And so then the employer would be aware that you filed that complaint, and that if you are terminated a week after the employer receives that, again, that looks a lot like discrimination. And then the employer took an adverse employment action against the plaintiff, and a causal connection exists between the alleged adverse employment action and the protected activity. So again, there has to be a connection. Sometimes things can look like retaliation, but the employer is able to provide that legitimate non-discriminatory reason that we talked about earlier. This case talks about retaliation. Another police officer had a seizure on the job, and he was passed over for promotion even though he had the highest score on the exam. He was given After the seizure, he was given more administrative work and less investigative work that he had done fairly well prior to the seizure. He at that point filed a claim with the EEOC, which again is within the Federal Department of Labor, claiming discrimination on the basis of his epilepsy. And after he filed that complaint, they started to treat him worse. He was given less desirable shifts to work, even though there were less senior officers available to work those shifts. He had submitted a doctor's note saying, asking for him to work days only, and they would not accommodate that doctor's note, saying it would cause a burden with the other schedule, the schedules of other individuals. And they involuntarily placed him on disability leave and again passed him over for promotion. So in that case, the court held that yes, he did have a claim of retaliation because he filed that complaint, and then things went downhill pretty quickly from there. And then lastly, to keep in mind, I just wanted to touch on the Family and Medical Leave Act. It's separate and distinct from the ADA, and there's federal FMLA and state FMLA, and I won't go through all of these slides in detail, but it talks about how if you're an individual with a disability, you have the right to take a certain amount of leave, and for, let's see, this one talks about, this is the qualifications for the state one, and then you could do a whole presentation on the differences between the state and the federal FMLA, so I'm going to just try to talk a little more generally, but I think the federal one is a little broader in that it applies to employers with 50 or more workers, and the state is 75 or more workers. So the state protects larger employers, employees working for larger employers. And under the state, you get a little more leave. But you can use FMLA to care for a spouse, son or daughter, or parent if they have a serious health condition, or if you yourself have a serious health condition. So if you need to have surgery, if you need to take time off because you're changing medications, or you need to get your medications levels right before you're able to continue your job, any reason you may need to use leave. If you have a seizure and you need to take a few days off to sort of recover, that could be covered by FMLA too. You would need to present medical documentation to your employer that, you would need to get a certification from your doctor. So you would need to provide that. But then, you can take it on an intermittent basis. So like I just said, if you have a seizure and you need a day or two off, that could be covered by FMLA. So if you're covered by the FMLA, and the employer is not giving you the benefits provided under one of those laws, and you ask to take FMLA leave because you need some time off to deal with your medical condition, that could also be give rise to wrongful termination as well. And you can file a complaint based on a violation of the Family Medical Leave Act. You can file with the Connecticut Department of Labor. And again, just to keep in mind that here, there's also a 180-day filing deadline. So it comes up fairly quick. If you feel that the employer has violated your rights under the Family and Medical Leave Act, that's also a potential cause of action for wrongful termination against the employer, and you may be able to get some relief through a complaint with the Department of Labor. So I think if anyone has questions, I'll be happy to answer them. I know we went through a lot of information fairly quickly, but I think it's just important to remember, if you feel that the employer has discriminated against you because you've told them that you have epilepsy or a seizure disorder, or they have failed to accommodate you in some way, for some reason that doesn't seem like it should be an undue burden, you're asking for something that's reasonable and doable by the employer and they're failing to do it, or if you're advocating for yourself and they retaliate by terminating you, those are all potential causes of action. That those could all be discriminatory, and you certainly have the right to file a discrimination complaint. And just remember, you can talk to an attorney, or you can go ahead and do that on your own, but just remember to do so fairly quickly within those 180 days. So I guess, Monica, does anybody have any questions?
Those who are on the webinar here, yeah, if you want to type some questions at the bottom of your screen, we can go ahead and answer those. You'll see a little chat bubble, and that's where you can type the questions. I did have a few while we're waiting. I was wondering if you could let us know what section or what statute number in the ADA where it does reference epilepsy. I believe it was one of the first slides that you showed.
Yeah. Let me go back to that. Probably an easier way to do it. No. So it looks here like it's in the Code of Federal Regulations. So 29 CFR section 1630.2.
Okay, and would that be on the ADA.gov website?
It should be. I believe they have the regulations posted on there, and they should have the table, so that you should be able to find this section. It's also in the, as you see above, in the interpretive guidance, because again, remember they passed the law. I guess this actually says 1994, but they passed the law in 2009 just to make sure that courts weren't construing things too narrowly. And, because prior to that date, there were certainly cases where individuals with seizure disorders or epilepsy were filing because they believed they had been discriminated against, and courts were saying, well, you don't have a disability that meets the definition of, under the ADA. And then Congress came back and said it really should not be construed that narrowly. It's, should be construed in favor of broad coverage. And it shouldn't be a very hard standard to meet, and so this talks about how epilepsy substantially limits neurological function. And again, it doesn't need to be all the time, just when it's even if it's episodic, when it's active, it's going to substantially limit neurological function. So it should count.
Okay. Thank you. Yeah, it's a good thing to print out and highlight, just for reference.
Yeah.
And also, just to clarify, so if somebody is working, holding a job, and their employer currently does not know about their epilepsy, and then they happen to have a seizure at work, the employer finds out. So is it more difficult at that point if the employer says, okay, you can't work here any longer? Let's say they use another reason. They may not say it's due to the fact that they had a seizure, but did you say that would be more difficult at that point to file a complaint because the employer wasn't aware?
Yeah, I think we had talked about a case last time about an individual that was terminated, and I think the situation there was he had some sort of seizure while working that sort of, when he was having his seizure, he kind of disrobed and was sort of non-responsive. And I think it wasn't until after they had made the decision to fire him that he then came back with, his first medical documentation that said he did in fact have a seizure disorder. And yeah, I mean, I think it's a hard thing, right? Because if you have a seizure disorder and you feel it's well controlled with medication, and you haven't had a seizure disorder in years, you may feel there's absolutely no need to tell your employer. And, you would hope that an employer wouldn't treat you differently just based on that information. But, especially if you think there's some sort of reasonable accommodation that would allow you to do your job, to perform those essential functions. I think it's good to disclose, and then I think you have those protections, right? If they do if they do take some adverse action against you, you're then at least able to say, I provided this documentation. My doctor said I had no limitations. My doctor has cleared me and said I can perform all the essential functions of my job. I only need this one, minor reasonable accommodation, whatever it is, it should protect you. And that being said, I mean, sometimes you provide that information and employers take discriminatory action, right? So it can be a double-edged sword, but you hope that the hope is always that employers are going to comply with their requirements under the ADA, and once you've told them they are required to sort of engage in that interactive process of reasonable accommodation if that's necessary. And certainly if you work in an area, as we talked about, where there's a threat to health or safety,
Mm-hmm.
even if there's a very low risk that you may have a seizure while on the job, that might be something you want to discuss with your employer. So yeah, I mean, I think it's, if you at all have a fear that you may, if a seizure may present at work, then I think it ultimately protects you to share that. I'm sorry. To share that with the employer.
Okay. But even so, though, if they have a seizure, that's still not grounds for them to just release someone from the job, even if they didn't know about it.
Right.
Okay.
Yeah, I think, again, you hope that's not the case. The cases we talked about where that happened was where the direct threat was involved, the police officers who are carrying guns, or if you work in a very high risk or hazardous environment, that could be the case. But if you are working in a grocery store and you have a seizure, there's no threat to health or safety there, and you should be able at that point to bring in medical documentation and say, yes, I have a seizure disorder. This was a very rare occurrence. I'm able to perform the essential functions of my job. And if that did happen to somebody, if they had a seizure on the job and that was the only cause for them being fired, there was no other potentially non-discriminatory reasons, I would encourage that person to think about filing, or at least consulting with an attorney, who could advise them on that. Because that, again, you hope that wouldn't happen, but I'm sure it probably does in some situations.
And if somebody does want to file with the CHRO, is it best to call the office? Is it something that they can do online or by printing out forms? What would you suggest as being the best way if they're ready to file?
There are forms online, and on their website, it kind of walks you through it a little bit. If you're filing, it depends, I think, on how comfortable the person is. Most of my clients will go in and meet with somebody. And I think it's a comfort level thing, or maybe CHRO sets up appointments with any pro se parties. I'm not entirely sure of that, but they will go in and sort of talk you through it and they're a very helpful resource in that regard. But if somebody felt like they've read everything online and they're able to draft a complaint on their own, that they could probably go ahead and do that as well. I think it's just based on what they're comfortable with.
Okay. That makes sense. Well, this webinar has been recorded, as all of our webinars are, and will be provided on our website at epilepsyct.com. So this is definitely one of these webinars I feel like that would be helpful for people to just review every now and again, just to be reminded. As Amy pointed out, this is a lot of information. So you are able to go back once the recording is available to just go back and kind of listen to it again. And it will be a reference for you in the future too on our website. And as I believe Amy showed too, that the Greater Hartford Legal Aid is also a resource for you here in Connecticut. So if you have questions, if you want to connect with them, they are available as well. So thank you, Amy, so much for this information and for your time and for just helping us to understand the law, really, which can be difficult for us who are not lawyers to understand, but very important for us to know about. So thank you.
Welcome.
And I hope everyone has a good weekend.
Thanks. Take care.